So this is We the People News. One more time. Alright, so this is going to be news. Alright, now I'm making this video without prejudice and or without recourse. Alright, I'm not waiving any of my rights whatsoever, y'all. I never look straight forward. I always look around me to be able to protect myself by any means necessary. However, I'm not an attorney, so whatever is said and done on this video does not reflect of my opinion or anything like that. Anything that comes out of my mouth is going to be my opinion. It's not going to be legal advice. Sometimes it sounds like it, but it's not. It's just my opinion. And we're just going to call this one Chris. Alright, now if you've seen some of my videos in the past, then you know who I'm talking about. Now, we're going to check out this new Supreme Court ruling. Alright, wink wink ruling. Okay, it's opinions, y'all. Alright, now let's go do a little investigation, alright? Roe versus Wade was a state issue. However, they brought it all through the United States, but it was only a state issue. So this next Supreme Court on the Second Amendment was a New York opinion. All right, it does not attend to any other states at all. However, everybody out there is going to seem to think it is, and it may spread out to other states, but technically, it's not supposed to be that way, just like Roe versus Wade. Alright, it is technically a state issue, and since this Supreme Court brings it up, the other states may follow through and by using it. But in all actuality, it's only for New York. Okay? And let's check out who knows a little bit more about this, because I have not actually read this opinion, right? I've seen a couple of videos out there, all through there. I did hear about it, but I was too busy to actually check it out for myself. So this video is going to be hearsay, and all the other ones are going to be hearsay because I never read it. So it's just going to be on my opinions if I do intervene. And it may be a two-part video because we need to fully understand what the situation is at hand so we know how to act in a particular way. Now remember, I had a video out there. I defined what the Second Amendment says. If you haven't looked at the video, then go back and look at it. It's clearly defined, and I'm a firm believer that all the Supreme Court judges needs to wake up and realize they can lose their job and be impeached. Just a simple fact, they've been doing unconstitutional rulings for a long time, y'all, and they gotten spoiled and out of control. Every now and they get it right, every now and they don't. It's kind of hanging a slap of beef for a dog in the tree that dog cannot reach, but it keeps trying and trying and trying. Alright, let's proceed forward, y'all.
The Supreme Court ruled, or the Supreme Court ruling. I will never say those things because kings issue rulings, courts issue opinions. And there is a distinction that should be understood from the American people, that this is not a body that rules over us. This is a body that offers its opinions regarding laws and their application through the Constitution. And so what I want to do is give you a really brief breakdown right here on what this case, what this opinion does not do, what this opinion actually does do, and what we learn from the opinion about the Supreme Court itself and its understanding, not just simply of the Second Amendment, but of our rights. And then we're going to go into a more in-depth look at the case itself. For those of you who want the more in-depth look, stick around with us after the breakdown. And in the breakdown, I'm just going to give you some bare facts, but in the understanding, in the in-depth view, I will actually show you from the terms of the text itself, from the opinion itself, why what I'm telling you is absolutely true. So, what does this Supreme Court opinion not do? Well, I'm not sure what the media is going to spin it out, because much like the impending opinion on the application of abortion laws at the state level, I anticipate much of what you will hear from the media will be highly exaggerated, over-emotionalized, with a great deal of spin. Which is why it was felt it important to bring this to you as soon as possible to help counter the fear, the factor, the emotional spin, and the manipulation that comes from the exaggeration of the media, the politicians, and the pundits, who are just simply looking for higher ratings and more followers. So let me explain to you what this opinion does not do. First and foremost, this opinion does not change anything in any other state. I don't know how to say it any simpler than that. This opinion does nothing to change anything in any other state. And when you stick around afterwards and I show you through the opinion itself, we're going to hear from Kavanaugh, who's going to tell you that exact thing itself. This opinion does not change anything about any other state. Number two, this opinion does not restore a proper understanding of the individual's right shall not be infringed. As a matter of fact, once again, this Supreme Court deeply, thoughtfully analyzes every single phrase in the Second Amendment, and then at best glosses over shall not be infringed. As a matter of fact, in this entire opinion, 135 pages, shall not be infringed is only mentioned twice. They cannot analyze that phrase, because when they do, both the conservative and the liberal justices' arguments fall to pieces. So this does not change anything in any other state, and it does not restore the proper understanding of an individual's rights shall not be infringed. And number three, it does not expand individual rights to keep and bear arms in the eyes of the Supreme Court or the government. So this is not an expansion of your individual right to keep and bear arms. This does not mean that other states are going to stop issuing permits. That's not what's going to happen here. So I don't know what somebody's going to tell you, but that's not what this case does. Now, what does this case do? New York State Rifle v. Bruen, the Supreme Court reasserts D.C. v. Heller as the standard for gun control. Not the Second Amendment as the standard, but reasserts D.C. v. Heller 2008 Supreme Court case as the standard for gun control. Number two, this case keeps in place a judicial precedent and a political understanding that the right to keep and bear arms is not actually a right, but a regulatable permission based upon justifiable needs of government. Remember, if it's a right, it's not something subject to government regulation. If it's subject to government regulation, then it's a privilege that is granted to you by permission, by permit of government, with the equal authority to take it away from you. A right, as the Declaration of Independence.
Now remember, regulation, right? They're getting that term, regulate. The militia needs to regulate, right? Keep everything in working order. However, the government confiscated that word to their benefit. And like I said on the other video, that was not the Founding Fathers' intent.
states is inalienable. It is a natural right bestowed upon you by your Creator. Unalienable, meaning government can't take it away. Which begs the very necessary question, what if I hurt someone with my gun? Isn't that the government taking my right to keep and bear arms away justifiably? And the answer to that question is simply no. Because if you hurt someone intentionally without cause, outside self-defense, with your gun, the government is not taking your right away. You have relinquished it. You have given up that right by harming another person with its use. You do not harm another person by carrying a gun. You do not harm another person by letting them see it and being scared. The only justifiable means to take someone's firearm away from them is when they hurt someone with it. Sorry, hate to give you that bad news, but if it is a right, that is the only limit it ought to know. And the Supreme Court today has reasserted that the right to keep and bear arms is not actually a right. It is a privilege that is regulatable based upon justifiable needs of government. What this opinion does do is narrows the definition of justifiable needs of government. So the government in New York, the Supreme Court said, went too far with the justifiable needs of government, and they have to scale it back to the D.C. Heller standard. Now, what do we learn from this? We learn that our Supreme Court still believes government is justified to regulate our natural rights. That this Supreme Court does not agree with the Declaration of Independence, that we hold these truths to be self-evident, that all men are created equal and endowed by their Creator with certain unalienable rights. Among these, life, liberty. See, you have no right to life if you have no individual right to defend it. If you do not possess an individual right as defined by the text of our Declaration of Independence, and as we'll see in a little bit, as defined by the founders themselves, then you don't have a right to life. You also have a permission to life. You have a permission to life bestowed upon you by whoever is tasked with defending that life for you. The only way you have a right to life is if you have a right to defend it, as Samuel Adams says, with the best means necessary. I actually have a quote for you.
All right, gonna pause it there again for a second. This is not complicated, people. Really, if you don't have a right to bear arms to protect yourself, and second motion that, right? The Supreme Court also said it's not the duty to the cops to protect you. So what it is if you sit and think about it, is all the other countries has been taking their weapons is for the government to take control of you. It's just plain out simple. We're just a little bit behind, and the government is slowly doing this. However, our country, is only 250 years old. These other countries are thousands of years old. So we're actually doing it really, really fast compared to other countries, y'all. But then think about it. If the government has no duty to protect you, and then you have no duty to protect yourself, then where do we, the people, stand?
From Samuel Adams. Christian's going to put it up there. Samuel Adams wrote in 1772. Give me a thumbs up when we got it, Christian. 1772. Among the natural rights of the colonists are these: First, a right to life. Secondly, to liberty. Third, to property. Together, number 4, with the right to protect and defend them in the best manner they can. That number 4 there is an illustration that, guess what? Your right to keep and bear arms is a natural right. A natural right that stems from the first law of nature, the duty of self-preservation. Self-preservation. Not the duty to preserve someone else's life, not the duty for the government to preserve yours. The first law of nature is your duty to preserve yourself. Stemming from that is an unalienable right to defend that life, that liberty, property, all those things necessary to the maintenance and securing of life. And so we have a Supreme Court that doesn't believe that. Still. This is still a living, breathing document, court, albeit a more conservative-leaning one. This opinion is full of the errant doctrine that everybody knows more about the Constitution than the people who wrote it, and that the opinions of those after 1850 are relevant in understanding the meaning of something written in 1789.
I had to go a step further, y'all. Remember in my last video, right? Excuse me. The Supreme Court knows this. They're not that stupid. They read the Second Amendment. They know there's 4 elements to that Second Amendment. They know about the comma in that deal. And however, they still violate your rights. Didn't think about that, people. If we can figure out that there's the 4 elements to the Second Amendment, then the courts can too. And I'm just an average man. So what is the Supreme Court telling you? Just saying.
I mean, seriously, when you say it that way, raise your hand. Does it sound ridiculous that someone after 1850 is a better authority on the meaning of a text written in 1789 than those who actually wrote the document, or by those who actually ratified the document in 1791? Are we supposed to believe that the writers of 1867 know more than the drafters of the very words themselves? Raise your hand if you think that's a ridiculous statement. But that's what our Supreme Court operates on. And then finally, this Supreme Court, in its majority conservative leanings, conflates the term history with original intent. This Supreme Court, this opinion written by Clarence Thomas, and you'll notice in this that Justice Breyer, although no longer sitting on the court, Justice Breyer has a written opinion in here. You won't hear from Brown Jackson because she didn't sit through the oral arguments of these. Breyer is involved in this because, unlike Ruth Bader Ginsburg, he retired, he didn't die, so he actually gets to finish out his cases. But this court, throughout this document, conflates history with original intent. And that's what I'm going to show you. We're going to look at the opinion itself. Don't worry, don't freak out. We're not going to do all 135 pages, but I have pulled out some very significant sections that you should be aware of that helps you understand why I said what I said. That this opinion doesn't change anything in any other state. It does not restore the proper understanding of an individual's rights shall not be infringed. It doesn't expand an individual's right to keep and bear arms in the eyes of the Supreme Court or government, so don't expect any laws in any other state to change. It reasserts D.C. v. Heller as the standard for gun control. Keep and bear arms is not a right. but a regulated permission based upon justifiable government needs. But that justifiable government needs is now more narrowly defined, which, by the way, has really ticked off the governor of New York. Christian, get ready the clips. Or give me a thumbs up when we're ready to play those clips. You got them? All right, let's play the first one, which is really short, and then give me a second.
New York Governor Kathy Hochul is speaking right now. Let's go to those images.
Check with the leadership. We're just looking at dates. Everyone wants a little bit of time to digest this. But I will say we are not powerless in this situation. We're not going to cede our rights that easily, despite the best.
Did you hear that? We're not going to recede our rights. Where's the people's rights, y'all? She is plainly saying the government has absolutely control over we the people. Just saying that you, we the people, don't have rights. That them, the government, has rights.
Efforts of the politicized Supreme Court of the United States of America. We have the...
This is...
Put it aside. Really? The courts are on your side majority of the time, lady. Just because you didn't get 10%. They took 10% from you? Really? Oh my goodness. Majority was still on her behalf instead of we the peoples. That's the reason why I say we need to impeach them and say, hey, your job is not lifetime.
Is a very interesting statement. What the governor of New York has just explained to you is that she feels that, number one, New York is a sovereign and independent state. And number two, that the Supreme Court does not issue rulings upon New York, but offers opinions based on their law and the Constitution. And she admits that the Supreme Court can be highly politicized. This is monumental, guys. This is life-changing. When Ruth Bader Ginsburg was on the court, when they were issuing opinions about carbon credits and imposing restrictions on private business and their green regulations of the EPA and the FDA's regulation of our firearms, these same people would have denied that a state is independent and sovereign and has a right to refuse these things. So this is monumental. This is amazing. This is absolutely fabulous that we now have more states coming on board realizing that, yes, you're not a colony. And if you don't like what the Supreme Court says, you don't have to comply. You may suffer the consequences of failing to comply, but you don't have to if you're willing to put up with those consequences.
And when you talk about consequences, what is she talking about is federal grant money to the states. This is all contract, y'all. The states have to have a contract with the federal government for their money. Alright? So everything they do, the laws they pass and all that, your state is stabbing you in the back to get federal funding that you pay for out of your taxes, out of your paychecks. So the state is signing a contract for the federal government that confiscates your money to turn around and give back to the state, and the state keeps the money and still tax you on everything else. Kind of double dipping, don't you think? Alright.
Which may be, lack of federal funding or a denial of certain commercial privileges. You know, there are certain things by contract that all the states enjoy. And if they do not submit to the Constitution, and unfortunately, if they don't submit to the cries of the federal government, then those are the kind of things they have to worry about. But it is still nonetheless very enlightening and very vindicating. Because if I had said that, and I did say that 6 years ago, I was an anti-government extremist hate group. I wonder if the governor of New York is going to be put now on the Southern Poverty Law Center's list of anti-government extremists. Just a question. Christian, are we ready with the second clip from her? All right, go
On the
ahead and play
Patriot
that second
Guys
clip.
list.
Told. They have now said that the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. That's it. No longer can we strike the balance. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Shocking.
Unqualified. Okay, government, you're impeding on our rights. And yet, unqualified? Government, you're unqualified to accept such demands of asking permits from we the people or demanding permits from we the people. Alright.
Absolutely shocking that they have.
Shocking, she says. Shocking that shall not be infringed means you have to come up with a better excuse. Shocking that shall not be infringed means you have to come up with a better excuse. Well, that you must look to history. And you'll see this throughout this opinion. Not to the Constitution. Not to the intent of the drafters. So I had a law professor tell me one time, well, you know, Chrisanne, the intent of the founders, the drafters, that's very interesting. We can't possibly know what they mean. They're dead. How are we gonna find them to find out what they mean? Well, guess what? We know what they meant. Because they wrote reams and reams and reams and reams and reams about it. Just like the chosen historians of the Supreme Court who wrote what they believed it meant, the people who actually wrote it wrote what they meant. Just shocking, to steal the words from the governor of New York. Shocking to me that we have to go outside the drafter's intent to even find meaning when they wrote so much for it. So remember, point number one, this doesn't change anything in any other state. Now, this Supreme Court opinion, I didn't put the whole opinion up there. It's a lot of words, but Christian's got the picture of the style of the case, so you can see it. You can find it for yourself. Does nothing to any other state, and this is Justice Kavanaugh's. This is Justice Kavanaugh's concurrence, and here's what he says. All right. By contrast, 43 states employ objective shall issue licensing regimes. Those shall issue regimes may require license applications to undergo fingerprinting, background check, mental health records, and training in firearms handling and in laws regarding the use of force, among other possible requirements. Going forward, therefore, the 43 states that employ objective shall issue licensing regimes for carrying handguns for self-defense may continue to do so. So, what is the problem? Well, Kavanaugh tells us what the problem is. The problem is not New York's regulation that you have to get a permit to carry. The problem is how the regulation is enforced. Here's what he says. New York's outliers may issue regime is constitutionally problematic because it grants open-ended discretion to licensing officials and authorizes licenses only for those applicants who can show some special need apart from self-defense. So the problem is not the regulation. The problem is how it's enforced. Now, I want to also address with you this issue, like I said before, that the Supreme Court believes that your right to keep and bear arms is a justifiable permission. It's not actually a right. It's justified by the needs of the government, and how what we learn is that the court conflates history with original intent, and that this is a living, breathing document court still. I'm going to read to you what Kavanaugh says here, and then we're going to go to what Amy Coney Barrett writes. He says, as Heller and McDonald established, and the court again explains, the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. Properly interpreted, the Second Amendment allows a variety of gun regulations. This is Justice Kavanaugh. Properly interpreted, the Second Amendment allows a variety of gun regulations. You see, if you properly read it, you know it's a regulatory straitjacket. A properly read Second Amendment, a properly understood Second Amendment shows you that it is a regulatory straitjacket. But if you properly interpret it, we can do whatever the heck we want. And that's what Kavanaugh says. Right? Well, how do we do this proper interpretation? Well, listen to what Amy Coney.
Alright, so I'm going to stop here and make another video. It's 32 minutes long. So this is We the People News. Not for me to decide. Y'all think about this crap. Alright, so Ann Hall. So I told you the first name in the beginning. Ann Hall. Alright. Till next time. Bye.